All rise. The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the courts now sitting. Please be seated. Good morning and welcome to the Kansas Supreme Court. This morning, we'll have two cases that Mr. Shima will call the docket in just a minute. Before he does that, I did want to make some general comments, most likely to anybody that might be watching on our live stream, as I know those who are in the courtroom are very familiar with the processes that the court uses in its oral arguments and other proceedings. So for those who may be listening, just to explain a little, that the court has received written materials related to each of the cases we will be hearing today. Those include briefs and other writings, and the records that were developed in one case at the trial court through a jury trial, and another case in an administrative proceeding in discipline. So we are familiar with the facts, those records, and the arguments of counsel. But today gives us an opportunity to ask questions and probe deeper into some of the matters with the attorneys who are here today. As we do so, we may be looking at some of those documents that we have either on our computer screens, or some of us still use paper. So, and maybe more of us use paper today than we did 2 months ago. But regardless, we do have some documents that we may be consulting. And I want to assure everyone that when we do that, we are still attentively listening. We are just trying to verify or check our notes, or do some other way help us assimilate the arguments that are being presented. With that explanation, I would ask Mr. Doug Shima, to clerk of the Kansas Appellate Courts, to please call the 9 a.m. docket.
Honor, may I please start? First case on the 9 a.m. docket for Friday, December 15th, 2023 is appeal number 125637, State of Kansas versus Danny K. Williams, Shawnee County. Briefs both sides.
May it please the court. Good morning. I'm Joe Dash. I represent the appellant, Danny Williams. I always forget this, and I'm present and ready for argument.
May it please the court, the state appears by Deputy District Attorney Jody Litvin, present and ready for argument.
Second case is appeal number 126106 in the matter of Richard K. Davis, original action and attorney discipline.
May it please the court, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office. I'm present and ready for argument.
Thank you. May it please the court, Richard K. Davis appears pro se. I'm present and ready for argument.
Your Honor, that concludes the docket for the week of December 13th through 15th, 2023.
Thank you. I will now ask the attorneys in 125637 State of Kansas versus Danny K. Williams to please come forward. Approach as soon as you are.
Ready?
Yes, I
Okay.
think so.
I'd like to reserve 3 minutes, please.
All right, 3 minutes is reserved.
Again, good morning. May it please the court. I'm Joe Dash. I represent Danny K. Williams. Facts of this case are pretty simple. There were two teenagers that were having some sort of a dispute. They brought their teens and one adult into the mix, which resulted in the tragic death of one of the teenagers occurring during a shooting car chase. Danny Williams was convicted or charged in the death of both felony and premeditated murder, and was convicted of each. 3 people were charged in the death and tried separately, with Williams being tried on an aiding and abetting theory. Mr. Williams' case, the state offered and published to the jury after it was admitted a video of the victim being treated for his fatal injuries at the scene of the crime accident, because there was a car accident which preceded his death. Appellant here asserts that the admission of this video is erroneous due to its prejudicially gruesome nature and complete lack of relevance or materiality to the state's case. Appellant would respectfully submit this error was principally due to the district court's failure to review the video prior to its admission and when the objection was lodged. Video itself, well, it speaks for itself. And I apologize for my late request to view it, but well, we're not capable of doing that here in the court, or it's just not that important because you all will have watched it. I certainly know that you will have, which is a lot more than the district court did beforehand, as she didn't watch the video before admitting it.
Let me ask you this.
Yes.
The one note that I put down in my papers when I was going through this. So, you know, we've seen arguments about autopsy photos being too gruesome to be admitted, and I'm not sure I've ever seen a case where that argument prevailed, certainly since I've been here. So what's the difference with what you have with something that we've considered before and kind of uniformly rejected?
Difference here, Your Honor, is that we're not talking about the dry and clear pictures. We're talking about watching a child die in front of you, which if there's a dying declaration or something like that, or as I've experienced in other cases, I'd understand that. But there was no probative value whatsoever to this case, none.
Let me push back on that a little bit. I've seen the video. And I agree. I mean, it's a tragic circumstance, right? But tragic, gruesome crimes create gruesome images. At least our case law suggests that. But when you watch the video, you can see as the officer approaches the vehicle, bullet holes in the window. Then you see it is an occupied vehicle and the victim that has been shot. Here, the felony murder, or at least the felony underlying the felony murder charge, is unlawful discharge into an occupied vehicle. Seems to me that the video is quite relevant to the elements of that felony.
Well, how I'd reply to that is, at what point does it retain that relevance when you're getting into the car and seeing this person? The state's proffer at the time of trial was, well, it's going to show his position in the vehicle. That's irrelevant. That's just a stupid argument, to be honest. There's no importance to where he was in the vehicle. He was shot, period. If he was in the passenger seat, if he was in the back seat, well, it doesn't matter. Anybody that was shot in that car was shot in the car, inside the car. And the second argument made by the state was that, well, it shows where this handgun was found. Well, actually, the video doesn't show where the handgun was found. There's some hearsay statements of where a person came in and said, I put this gun up on the dash of the car, or not on the dash, but on the hood of the car. That's irrelevant too. That has nothing to do with whether Mr. Williams, what his participation was in this crime, what,
It corroborates their motive.
I'm sorry.
But doesn't that corroborate the eyewitness testimony who said they saw him in the vehicle driving the car and
As far as I'm concerned, and I know that that's not necessarily what the state has to prove, what does it matter? The case was that one person shot into the car and killed them. But what led to that shooting really doesn't make much difference. I mean, it does in some respects to show the general outline of what's going on, but when you see the actual other videos in this case that show that there's a man shooting from the top of the car, shooting into this car, I don't think there's really anything else that they needed. So is it cumulative? I guess that's not an argument they made in the district court. They didn't make many arguments in the district court. It was a very unusual objection.
isn't the fact of retaliation relevant to the people who were shooting at the?
I would say, honestly, Your Honor, I would say that goes to, and I'll concede in some respects, yes. But also the question is, what was the intent of Mr. Williams as it related to Mr. Johnson's decision to take an assault rifle and to shoot at these people? Now, had there not been an assault rifle, and I wasn't going to go on this bandwagon, but I will for a moment. Had there not been an assault rifle, we'd have a different picture entirely. That death would not have occurred had we not had an adult that decided to come, I'm going to join in and kill somebody. We'd have had two kids that were shooting in the air like they were to begin with and, you know, driving around like idiots. Probably not likely they would have shot into the back of the car and killed anyone with a handgun. Not likely. Now, I didn't want to get on that bandwagon, but I'll just say that there's really no reason this had to happen. And there's really no reason that this did happen other than one person, Mr. Johnson, decided he wanted to join in and kill someone. I don't think that the intent of Mr. Williams was to kill anybody. It was to go scare somebody. See, you slid in another part of this transcript. He slid up on me. I want to go slid up on him. Okay, do the same thing, not shoot and kill him. However, you know, that's what we're dealing with right now because somebody tragically died because of the decision of one adult and to join into two children's squabble.
Can I move you to the, you brought up the issue of it's an abuse of discretion
Yes, sir.
for the trial court not to have viewed the video prior to its admission or taking up the issue. And as I understand it, the issue was brought up pre-trial, the gruesome nature of the video, or was it done during trial?
Yeah, well, okay, there's a problem with that. The first lawyers in the case brought up the gruesome autopsy photos as if they would be gruesome, not knowing whether they would or wouldn't.
Okay.
That was deferred to trial on gruesome photographs. This was not really raised until the video came to fruition and was admitted. Unfortunately,
So are you saying defense didn't view the video either before it was admitted?
I
It
think
wasn't
she
part of
did.
the discovery?
Yes, it was part of the discovery, and I believe she did view it. But I do not believe that she made an objection she made an objection before it got on, but there was no pre-trial objection. It was made within the middle of the trial. So it's an unusual situation. Well, it's unusual in two respects, because it's a video and of what it shows instead of what it shows, that it doesn't show the results. It shows.
Do you have any support for your proposition, I suppose, or your position that a district court must view evidence prior to its admission? A proffer isn't good enough. Essentially, that's what you're saying by if the district court had bothered to look at the video, absent that, it's an abuse of discretion.
Yes, that is the position I'm taking. Why am I taking
Explain
that?
that to me.
Because it's,
You don't have any case support.
no, I don't.
Okay.
It's a district court's job to review evidence for gruesome decision. It's got to make a decision based on its own information. The proffer was not accurate whatsoever. It was not accurate whatsoever. It said, well, it's just going to show his position. Who cares? It really showed, it showed a tainted crime scene where two people were already in there taking care of this kid, trying to take care of this kid. And I'm sorry, I'm being cavalier. I'm not trying to be. It did not show what the state suggested it would show, or if it did, that was immaterial to its case. So being that, and I'm gonna get to the point, I'm getting there. What should a district court judge do when they're, approached with an objection to the gruesome nature of photographs? Should they take the state's word for it, or should they actually do the job and review the video beforehand to determine what it looks like? Because there was no suggestion on exactly what was going to be in the video. It said it's going to show the position in the car, and I don't know if he actually said the part of that, the gun, or not when he made the proffer. However,
Well,
what
it
is
doesn't,
the judge supposed to do then?
it doesn't change the standard of review that we have though,
that's true.
which is
Mhm.
we have to review it for abuse of discretion.
Right.
It either was or wasn't.
Sure,
That's based only on what the evidence shows.
that's true.
How do you respond to the state's argument that your arguments as to relevance of the body cam footage was not preserved because there was only a contemporaneous objection to gruesomeness and not to the relevance at trial?
How I would respond to that is that part of the standard review, and it's part of the thing that it's part and parcel of the refute process you should make before admitting evidence. Has to be, evidence must be relevant and it must be, more probative than prejudicial. That's part of the initial, it's part of the whole thing. And you can't parcel out that particular argument simply because they didn't make that. They asked for gruesome instead. I'm sorry, unduly prejudicial. That's part of the argument. It's part of the unduly prejudicial analysis. So I think you have to make the relevance argument. And whether she did or not, whether her trial counsel did or not, I had to make that argument no matter what, because it's part of the analysis. So I apologize for bringing something up that we take what we're given when it comes to an appeal, and I did what I could with what I had. So that's what I can tell you with that. With that, my time is about up, and I think I've made the arguments that I need to make. I will say one thing, and I did make a note on this. How would a reasonable person rule on the probativity of evidence if it doesn't look at it? And that's the reasonable person standard we're talking about. How would a reasonable person decide what they're going to do with something if they never looked at it? So that's why I think that there's a built-in abuse of discretion argument there. District court can't make a ruling on a prejudicial nature of a video if they don't look at it. And it's published to the jury, so it's already out of the bag. So a decision after the fact that was made here isn't appropriate or legally adequate under the circumstances. And with that, my time is up.
No questions. Thank you.
Thank you very much.
Good morning. May it please the court. Again, this is Jody Litvin representing the state. I guess I'll just hit on the preservation argument, and I would agree with what you were saying, Justice Wall, on the relevance part, as that was not preserved. In our view, if you're going to get to more probative than prejudicial, aren't you saying it's already probative? You know, isn't it already relevant? And then we have to decide whether that relevance or probativeness is outweighed by the prejudicial effect. So we would stand by our preservation argument that the only thing that was really ever argued, because this was an objection, it wasn't even an objection, it was, can we approach, you know, it was a request for a bench conference. And then defense counsel basically said, hey, there's this video. There was a motion for gruesome photographs that was, you know, pursued earlier, but this video is probably going to be graphic. I don't know. And then the prosecutor made their proffer. So the state.
Had anybody viewed it besides maybe the prosecutor and obviously the proponent of the video, the detective or whoever is testifying to the officer? Had anybody viewed it prior to its being shown in court besides the state?
I don't think that anything in the record says that defense counsel viewed it. I mean, I would imagine that it was a part of discovery. There's no discovery, you know, issue being raised here. She knew about the video.
The way you said it, you prefaced just a minute ago, it's probably gruesome. I mean, that indicates to me that if that's how it was, if that's what entailed, if that was the discussion at bench conference, it doesn't sound like there's any specific pointing out that it is.
And Your Honor, I can't tell you, I mean, I don't know whether defense counsel watched it or not. She just said, obviously this is a body cam video, which I'm going to anticipate is going to be pretty graphic. I don't know. So
Okay.
I don't know how that's a relevance objection.
Right. No,
So I guess that's just my point in the preservation part. And this kind of points out the importance of preservation, because had there been some sort of pretrial hearing on this, the court could have watched it. But this video wasn't raised pretrial. It was the gruesome autopsy photos only. And that really resolved itself because the parties said, yeah, we can come to an agreement on these autopsy photos. We'll let the court know if we can't. And that was that. So we don't believe relevance was preserved, or the defendant's argument in his brief that this was cumulative evidence. So our position would be for this court to really only address whether this was unduly prejudicial. And our position again is that it's not.
But on appeal, we have to review both, right? I mean, it's a balancing question. So maybe the particular arguments that were raised on appeal as to relevance could be susceptible to a preservation argument. But in terms to understand whether district court properly exercised her discretion, we have to consider both, right?
She did make a relevant finding.
Right.
So, I mean, yeah, I think,
And isn't on preservation, isn't it really just whether the district court had a chance to rule on the grounds that are being asserted?
yes, Your Honor. Well,
I mean, I would word it that way, and it seems to me the district court not only had a chance to rule on relevance, but actually did in the process of overruling the group. It just seems like this isn't the best hill to die on.
and we did address in our brief the merits of everything. So yes, I mean, we would agree that the court did find it was relevant and more probative than prejudicial. And I don't believe I have any further comments unless this court. We would just ask to affirm the premeditated first-degree murder conviction in this case.
Let's see, no questions. Thank you.
State seems to suggest that relevance is built in. I would suggest that's not correct, especially under this analysis. The question of gruesome photos was deferred by the judge prior to trial. It was argued but deferred. Now, that was photographs, and this is a video. That is the difference. I would also suggest the relevance finding of the district court was based on the proffer and the proffer alone. And I do not believe there was actually a prejudice, probative over prejudice ruling. There was a relevance ruling. It's relevant. And there's always gruesome, so I'm gonna let it in. But that wasn't based on any actual viewing or review of the evidence. So I'm gonna suggest that relevance finding was not based on it was only based on the proffer of the, and that's actually made out in the briefs completely clearly. Based on the state's proffer, I'm gonna find it's relevant. And that's the only relevance made. Finding made. It wasn't made on the evidence itself. So that's all I have to say. Any other, if there's no questions.
I just had one question about the record that can help me clarify. There were autopsy photos that didn't come into evidence.
That is true.
And was it because the district court judge said, hey, this video's enough, we're not going to get into? Was there an actual ruling or was it made clear enough from the record that the state wasn't going to put on additional photos of the deceased because the video itself was adequate?
Yes. During the mistrial motion the following day, she made that ruling. The district court made that ruling. And I believe that is correct.
Other questions? Thank you.
Thank you very much.
Thank you to both of you for your arguments this morning. The court will take this appeal under advisement. We'll now call 126-106 in the matter of Richard K. Davis.
Hey, please the court, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office. Madam Chief Justice, I'd like to request 2 minutes for rebuttal. This is an original proceeding in attorney discipline involving Richard K. Davis. Mr. Davis was admitted to the bar in 2013. The matter before you involves 3 complaints that were filed against Mr. Davis and proceeded to a contested hearing on December 8th, 2022. Thereafter, on February 9th of this year, the hearing panel issued its final hearing report where it concluded that in 2 of the 3 complaints at issue, Mr. Davis committed several rule violations. The first complaint, DA 13-141, a complaint filed by court reporter Julie Ragsdale, The panel concluded that Mr. Davis violated 1.15A, safekeeping property, 3.1, meritorious claims and contentions, 4.1A, truthfulness and statements to others, 4.4A, respect for rights of third persons, 8.1A, knowingly making a false statement of material fact in connection with a disciplinary matter, and finally, 8.4C, engaging in conduct involving dishonesty. Second complaint, the panel found rule violations in was DA 13579. This complaint was filed by Sedgwick County District Court Judge Eric Comer. For that complaint, the panel concluded that respondent violated 3.5D, engaging in undignified or discourteous conduct relating to a tribunal based on Mr. Davis's conduct during the hearing before Judge Comer on October 2nd of 2020. And 8.2A, making a statement that the lawyer knows to be false or with reckless disregard as to his truth or falsity concerning the integrity of a judge based on Mr. Davis's claims. In his response to Judge Comer's complaint, that Judge Comer filed his complaint knowing that it was without merit and that he did so in retaliation for the legal arguments that Mr. Davis raised at the October 2nd hearing. The third complaint at issue, the one the panel did not find any rule violations in, was DA 13149. That complaint concerns respondents' conduct towards TR and JR. The ODA argued before the panel and now on appeal to this court that Mr. Davis's conduct towards TR and JR violated 4.1A, making a false statement of material fact to a third person, 4.4A, using means that have no substantial purpose other than to embarrass, delay, or burden a third person, and 1.15B, failing to promptly deliver the funds to a third person that person is entitled to receive. Facts of that complaint are, in early 2018, Mr. Davis was retained by a client to collect a judgment that the client had previously obtained against a person with the initials TR. Mr. Davis.
Before going into your objection. Or your exception, sorry, right? So that in just without going into hearing. It was 6 months, but it was 90 days. 90 days of suspension. And it kind of seemed like maybe they were leaning towards. They thought there was an issue with 90 days of probation and 90 days of suspension. Your office is recommending out looking on Westlaw to see, you know. I just wondered what you can tell me.
I'm familiar with other cases where, you know, the hearing panel and the disciplinary administrator's office does recommend different
Right, so am I,
sanctions. So here, I think that the panel gave significant weight to the evidence that Mr. Davis presented, specifically his medical condition and how that may have affected him during the pendency or during the time period of when these complaints arose. It seems like the hearing panel considered numerous ABA standards within the hearing panel report, which looking at them, many of them that they cited were applicable to negligent conduct under the ABA standards, where here the hearing panel found that Mr. Davis either engaged in intentional conduct or knowing conduct. So my argument would be that a lot of the ABA standards that the panel considered would not be applicable based on their finding that Mr. Davis engaged in knowing or intentional conduct.
But they did recommend, which is the ABA standard.
Yes. Intentional, I mean, a 90-day suspension.
I just don't, you know, down to it. I just don't understand. You know, I mean, it did seem like from your briefing that, that the response, his heart transplant effect of that, physically, and the medication, all the medication he was taking, and effect, I guess, of having it, so that it caused a lot of the violations. Look at this, the violations that occurred before his heart transplant were basically Ragsdale complaint. But then, you know, a lot of the Ragsdale complaint had to do with what after, you know, as part of happened after his heart transplant. Heart transplant. I just, what level of causation would you have him?
I don't think my argument was that he didn't prove the existence of that mitigating factor. My main argument is that if you look at the 2018 conduct involving Ragsdale, and then also my argument that the rule violations did occur involving TR and JR, that showed a more intentional dishonest conduct, especially when, you know, Ragsdale files her complaint and says that, you know, told me that he sent me a check for the funds that were owed to me. And he files a response saying, yes, I did. And I filed, in fact, I sent a check for the appearance fee to her. And go through the process and we find out that wasn't true, having to dig through the evidence, speak to the client, find out the client was not requested or asked or sent a check for that. And so I guess my argument was that I understand you have suffered a significant health condition, but I don't know if that health condition would result in him engaging in intentional dishonest conduct.
So
During our
I agree that
investigation.
was intentional. Let's say that we agree with the garnishment case. Don't consider the garnishment case, would you?
I would recommend a definite suspension with a reinstatement hearing. Those rule violations, if you find that there is no rule violations in connection to the TR and JR complaint. But I guess my thought is that this was a kind of a long, arduous process to get Mr. Davis to finally stipulate that he never requested a check from his client, nor was a check ever sent to Ms. Ragsdale regarding the appearance fee. Seemed like this was something that he could have acknowledged way earlier in the process. In fact, when he was responding to Ms. Ragsdale's complaint back in 2018. So I think I think the hearing panel found, and hopefully I laid it out clearly in my brief, that there was numerous instances of dishonest conduct going on in this case. And that should be recognized with a sufficient sanction that knows that that is serious conduct.
How far is a obligated to go? Help the Office of Disciplinary. How far is he obligated to help?
And you are filing a response to a disciplinary complaint to provide accurate and truthful information.
So what is the relevance then of other than providing accurate information?
I'm sorry, Justice, I'm not clear what your question is. What,
Well, I think some of what you show as inaccurate information was repeated. It was repeated to several people about the $37 check.
correct.
But is there anything else that you are alleging prosecute the case?
The fact that he was continuing to raise the story and then eventually have to reach out to the client, LY, and ask her, you know, did you buy this check? And she's like, oh, I'm gonna have to go back and through my records. And so it was a process of having to do that, where the story was made up to cover up the fact that he had told Miss Ragsdale a lie during a March 2018 phone call that he had sent her a check when he knew he had not.
Have to call her as a witness at the hearing anyway.
Ragsdale?
Right.
We did, but yes, but we ultimately entered into stipulations prior to the hearing that did not require her to testify.
Two things. First of all, Paul's respondent, why happens on March 19th, 2018. Go to court. This has, your office isn't involved in that at all. She did file a complaint with your office, and there was out, and he responded to that letter on July 31st. So about responds to a letter from your office, and 14 days after he responds, pays the $714.70 plus interest. After that, when this whole, ruthless pursuing of the lie about the $37.50, having to call the client and having to do, when the court reporter has already been made whole. Sounds like the office of a lot of resources, right? When all those resources, when the woman was paid.
He was paid after she got a small claims judgment against Mr. Davis.
Correct.
And Mr. Davis went to that hearing claiming that he owed her no money after he told her in March of 2018, and in fact sent 2 emails to her in February 2018, acknowledging her invoice and saying that he was going to pay her.
And for that, he should lose his
So
license.
then he
For
came,
that, he should lose his license.
I'm not asking for disbarment,
Well, what is indefinite suspension mean?
at least a 3-year suspension.
That suspended and not able to earn money.
In addition to the 2 other complaints that are against him as
Not
well.
counting one of them because there was
According to the fact finder.
talk about the Judge Comer situation, but
Mr. Stanridge, he came up with a story about he first acknowledged owing the court reporter money. Then when he tries to make this argument that I don't owe her money at the small claims hearing and that not loses, she files a disciplinary complaint against us. We look at it and we see that this is kind of interesting. He's acting like he's acknowledging that he owes her money. And so when he sends in a response to try to explain away this fact, he comes up with the story that, oh, I sent her an appearance fee check. So then we have to go through this process of determining whether or not, was that true or not? It was not.
Can I want to follow up if I may on some of Justice Standard's questions, but I kind of want to, if I can, just walk through the rule violations that were found
Sure.
and then ask you to help me understand them. So the first one that you're just now talking about, violation of 3.1 of basically frivolously defending the small claims action. Can you articulate again what was frivolous about the defense to the small claims action?
He had asked Ms. Ragsdale to stay at the deposition and so he could depose the opposing party. And then proceeds to, and after she sends him her invoice and he acknowledges it, tells her, as soon as I get money from my client, I will forward it to you. And then eventually claims owing her any money when she says, I'm going to sue you in small claims court. And so, I mean, basically the argument is that.
So you think that the conversation where he acknowledges the invoice and says, okay, I'll pay you, sort of creates a legal obligation to pay?
If you.
I mean, for example, what I'm thinking is if in fact there was no contract, there was no, I mean, this is a contract claim at the end of the day. And he may very well have lost. He did lose. But I'm struggling to see the frivolity of defending. A lawyer gets sued in small claims. Why can't they defend?
Sure, but he asked a person running a small business to do work for him. She did it. I don't think that you'd have to go to law school to understand that you would owe that person money after they've done work for you. So he may have a claim going to small claims court about the amount he owed her, but he didn't make that argument. What his argument was is that I owe her no money.
Well, what? Actually ordered the train. Was an oral agreement. Automatically, she said he ordered the transcript. Never ordered the transcript. I think what Justice Stiegel is saying is that all as lawyers be so that we're going to be disciplined for defending ourselves?
No. But
But if there's a factual dispute about whether the transcript was.
Ms. Ragsdale claimed that there was. His emails to her seemed to acknowledge the accuracy of her invoice, telling her that.
So
I
it's
will
that
send-
seem to acknowledge, and then just anything after that is just frivolous defense. I mean, that does seem to be the position your office took
Okay.
in this case.
I just want to and I'll butt out of this discussion, but is this the same case that Judge Scott presided over?
Yes.
And he characterized, I don't know how depositions are paid for. I find the actions abhorrent, unethical. If Ms. Ragsdale doesn't file a complaint with the disciplinary committee, I'm going to. That's how he summarized the
Yeah.
behavior. Okay, I just want to put that in context here while we're discussing it.
So if I can, I know you're out of time and I actually have a list of questions here, if the chief will indulge me or my colleagues. Rule 4.1A in the same, which relates to the same event. In the course of representing a client, lawyer shall not knowingly make false statement. Who was the client that the lawyer was representing in which this false statement was made in the course of?
It would have been LY.
I don't see that. How is that? This dispute with the court reporter was not, or at least I want you to explain to me how that was in the course of representing the client.
The court reporter had rendered services at the deposition where Mr. Davis was
Right,
representing.
but the
him.
dispute with the court reporter has nothing whatsoever to do with the matter which the lawyer is representing the client. I mean, this rule is designed to prohibit a lawyer from making false statements, material fact to a third person about a matter on which the lawyer is representing a client. And is it not?
A court reporter was hired in relation to a case. He was representing LY. He charged LY for the full invoice paying the court reporter. And so I think when he was making the comment to Ragsdale saying, hey, I've gotten a check from my client and the funds are to you, that was,
So the
Made
rule's
for us
broad
to represent
enough
client.
in scope to cover that.
yes.
Okay. And I guess I want to transition over to the Judge Comer complaint. Can you articulate what was the violation of 3.5D, undignified, discourteous, and degrading?
Yes, as indicated by the transcript of the October 2nd hearing, Mr. Davis was interrupting and talking over Judge Comer numerous times. He argued with Judge Comer after he had issued his ruling, going so far to say that this was an injustice, that his client was being railroaded, and Comer ultimately took.
Do we have
offense.
to, do we have to ask the question, was it an injustice? Or is it just the simple fact of saying this is an injustice? You're railroading my client because you want to go on vacation. I mean, does that just ipso facto violate this rule?
I think the whole scope of the behavior at the hearing.
Well,
was
in other words, what
what
I'm trying to get at is what if a judge really is being just totally unreasonable?
If the transcript would show that, then sure. But I think if you're going to make criticism or an argument, it has to be tied to how the judge is ruling. And the judge made several bases for ruling against Mr. Davis's client at the October 2nd hearing.
And then following up on that, your office then tagged the respondent with another violation, 8.2A, when the respondent said that Judge Comer's complaint was retaliatory.
That and also claiming that Judge Comer filed it knowing that it was without merit.
Well, again, that just, how is a lawyer supposed to defend themselves, I guess is the bottom line question.
Davis could have responded to Judge Comer's complaint by saying, I did not believe my behavior was out of line, or acknowledging that I lost my temper at the time, but not trying to.
Well, I read the entire however many page email response. I mean, it was pretty detailed. Strike me as overly emotional. He makes an argument, which may be wrong, but it didn't strike me as an argument that was fantasy. In other words, the transcript does show that the judge was anxious to go on vacation and was just not interested. I mean, even the judge's complaint to your office says, I'm leaving the country, so don't talk to me for the next 30 days. I trust you can ferret this all out. That's what the judge's complaint said.
Justice Stegall, I specifically attacked Judge Comer's integrity by saying that he was filing this complaint against him in retaliation for the legal arguments that he made.
And
he was also, he's attacking, basically trying to question a nefarious motive.
Well, and that goes to my struggle with this issue on both of these violations is, do we have to, or does the panel have to undertake an inquiry as to the objective truth or non-truth of what was said? Or is it just that even if a judge files a frivolous complaint, you can't say that?
Well, Judge Comer did testify at the hearing and testified specifically that I did not file this complaint in retaliation for the arguments that Mr. Davis made at the hearing. He denied that he did it to try to prevent Mr. Davis from appealing. And so he was present in front of the panel. The panel made a credibility determination that those were not his motives.
Okay, and I just have one last question, and not even exactly sure how to ask it. And I'll acknowledge up front that this is not a significant matter, but it seems sort of illustrative of a question I have, which is your office, during the proceedings below, the respondent attempted to admit as an exhibit a investigatory report from your office on a different matter that was occurring at the same time. And you pretty vigorously opposed the admission of that exhibit. And I guess I just want to give you an opportunity to explain why, because when I read that, it seems indicative of essentially a win at all cost mindset, as opposed to a let's put it all out there and see if we can really get at the full picture.
When it comes to investigative reports that either are generated internally or from volunteer lawyers, they're going out and they're speaking to witnesses, and then ultimately they are making findings of fact, and they're doing conclusions of law regarding whether or not rule violations have occurred. Even in instances where investigative reports are, say, beneficial to the disciplinary administrator's office, where they're finding numerous rule violations, we never seek to get those admitted into evidence. And so on the flip side, when you have an investigative report where they have made conclusions of law saying these rules weren't violated, we look at them as being essentially like expert reports that are going to the ultimate conclusion, and that's why we moved not to have it admitted. But ultimately, as you would see in the record, we entered a stipulation of exhibits where I agreed to drop my objection to, it was Exhibit W.
Right.
If he agreed to drop his objections to some of my exhibits.
Okay, that, I appreciate that. Thank you. It makes sense.
I would just,
Questions?
I would
Quickly wrap
conclude
up.
by, I believe that the ODA did present clear and convincing evidence of rule violations in relation to the TR and JR complaint. As far as a sanction goes, I would be recommending a definite suspension with a requirement of a reinstatement hearing. And I'll address any additional questions on rebuttal. Thank you.
Davis?
Thank you, Justices. I want to begin by apologizing, as I'm generally a very clear-spoken lawyer. As I've gotten here today, I realize I might not be as much as normal, but I will do the best that I can. What I want to talk to you about, I do want to get into some of these questions that were asked and some of the specifics of the allegations. But before that, I want to start and just talk a little bit about what I think is growth and learning, and part of what I think these procedures are for, and what the justice's role in these type procedures would be. I don't stand before you here today and claim that I'm perfect. I don't stand before you here today and claim that there aren't things that I would do different in every one of those cases, including the one that the panel found no violations. I think that a wise lawyer, experienced or inexperienced, can admit that in any case, if you looked back at the way you handled it, there are things that you probably would do differently, whether you win, lose, or you end up standing before the justices like I am here today. I don't disagree with that. I don't disagree that there are things that absolutely I would change if I could go back, and that I have changed in the way that I've handled other situations and other cases since those days. Where there's a disagreement between me and Mr. Vogelsberg is on 2 points, and it's number one, whether imperfection, which again, all of us attorneys are, is always an ethical violation, or they're all of the rules violated that he's alleging here today. And then 2, what the appropriate punishment is. And so as we look at that today, and I want to talk more about that, the appropriate punishment side, and what I would suggest to the court, I think that it's important to keep in mind that the goals, obviously, of the justices are not just to take a pound of flesh or to punish someone. You all have stated in pretty numerous opinions before that rehabilitation, that protecting the profession, that there are all of these other goals, and that every situation is unique to the circumstances. And so with that, I want to very briefly give a little bit of my background because I think it is unique to these circumstances and is relevant as you decide the appropriate punishment for whatever violations that you find. As has been stated in the briefs and was found in the panel findings, I'm the first person in my family to go to college of any kind. Not to become a lawyer, not to even go to graduate school. When I graduated from Colby Community College, I was the first person to get an associate's degree. I was taken out of my home in high school and placed into a group home. I attended 3 high schools my senior year. I didn't have a support system. I still, to a large extent, don't. And that's part of what's been probably gets me more emotional about these proceedings than anything is people like Cheryl standing behind me, because I've never had that in my entire life. And so I graduated high school from Salina, where I attended for half a semester. I didn't know anyone. The second half of it, I turned 18, so I lived in an apartment with patio furniture by myself. I made mistakes. Just like I tell you here today that I'm not perfect, I made mistakes in these cases. I made mistakes when I was 18, 19, 20. I, didn't pay some speeding tickets. I got picked up in some warrants. I just was stupid and irresponsible. And I learned from that. And, first I tried to go to college up in Nebraska with a friend who was a bad influence at the time. Didn't do very well. I drank too much, was put on academic probation, realized I needed to change, went to Colby, got my associate's degree, worked very hard to get admitted to KU because I wasn't at that level when I started at Colby, got my GPA to the point that I could. And then I worked very hard to get myself to law school and away from those friends and bad influences that I had at the time. Now, I don't say that because I think that it's some great accomplishment or that I deserve accolades, but to point out that people can change, people can get better, people can learn from mistakes and things that they do wrong. And these events that we're talking about here today were 2018. They were over 5 years ago. I'm a different lawyer now than I was then in many ways. I am a different person now than I was then in many ways. Not only has just natural passage of time changed who I am and how I react to things, there's been 2 very significant events that have changed that. One of which being these proceedings. I think that Nancy Putten, when she testified for me, former bar president, she talked about how even her, when she read these complaints, it made her look at her own career and her own practice and say, hey, what are some things that I could do differently? This makes you analyze, and it absolutely did with me. I've completely changed my practice of law to the fact that I, in a way, am not practicing law, but I am, and my law degree does come very much into play, but I'm no longer appearing before courts. I've phased out the litigation practice because I realized it didn't fit both my health and personality too perfectly. I opened a title company, which is a much more predictable, regimented position. It addressed some of the issues that I had, which do kind of tie in even with these complaints. Billing is hard as a lawyer. Getting collection from people is hard. Those were not skills that I had, partly because I'm too nice sometimes. And I wanted to write off people's bills, but the problem is what that does and what it did in 2018. When you're writing off half or 2/3 of your bills, you don't have enough money. So you take every client that walks in the door. Before you know it, you have 100 cases and you're overworked and you're making mistakes. And that's what I did. And that's how we got here. And that's what I've changed to be different and to try to make sure that nothing similar to these situations ever happens again. The other major life change, and you've all mentioned it previously, is I had a heart transplant in 2020. And obviously that makes you rethink everything in your life too. There were 3 different times prior to that where I was in a hospital and told I was lucky I didn't die, where I was sitting in the cardiac ICU. It's definitely something that makes you think about your life, what you've done and how you could do better. And so that's what I ask you to focus on here today. Again, I'll talk about these complaints in a minute, but more than that, I want you to just realize that I have grown from this experience. I will continue to grow. I will continue to learn. Whatever decision this panel or this court makes, that I read, I will take and I will say, what can I do differently? I have cooperated throughout the process, despite what may have been argued here a little bit with regards to the original complaint, but I have voluntarily drove into Topeka to meet at the disciplinary's office 3 different times. I've spoken with them regularly. When they asked for records, I got them. Like they asked for bank records, I got them. They didn't have to subpoena them. And I've repeatedly said to Mr. Vogelsberg and previously to Stan, who I felt like I had a very good relationship with until he left, I would do anything that they thought would help me be a better lawyer, whether that would be additional CLEs, whether that would be additional training, mentorship, whatever it might be, I was open to it, and I am still open to it. And if there's anything that this panel decides that I should do, I am absolutely there to do it. I did take time to try and craft a very detailed probation plan. I think that you had mentioned there was the technical argument about it, which I do want to address. But I went out and I tried to find what I thought would be the best possible practice supervisor. Cheryl is a former Kansas bar president. She was an administrative law judge. She has a lot of experience, a lot of time, and then she also just recently retired. And I think that that's relevant because it means she has the time to do this. She's driven to Overland Park to come see and meet with me. She'll call randomly. I can tell you that we have that kind of thing where she'll text and say, give me a call. And she asks questions about what's going on in the cases or what's happening, without me having the time to think about it, prepare for it. And again, her support has meant the world to me. And regardless of what you decide, if you do agree with Mr. Volkersberg, and take my license, I will still cherish the fact that I had the opportunity to get to know Cheryl better, or that I've had someone, actually support me, because again, I haven't had that. I haven't had a lot of friends. I don't have much family. I was estranged from them for a long period of time because of the stuff with my stepdad that led to me being put in state custody. And my sister died in a car crash. I just don't have support, and it's hard. And so, excuse me. So turning to the actual complaints, my time goes quickly, so do want to talk about them. In the Ragsdale situation, I made mistakes. I did not understand how court reporter billing worked at all. It was my first ever deposition. And to your point, Justice, I would make the argument that you were asking about, which is how can a lawyer defend themselves in a court case without having to worry about being here today? I lost. I now understand entirely how court reporter billing works. I've paid other court reporters since then before I phased out the litigation of my practice, and was no issues. But at that time, the way I understood it, I had not received a transcript. Payment was not due for it. And so, I made a defense. Judge Scott did very vehemently disagree with it. And the transcript probably doesn't even do it justice. I'm honest about that. And, and I'd say a couple things about that. I'd say, number one, he'd been practicing law a long time. He was an experienced lawyer. He knew how court reporter billing works. And now that I know that, now having that knowledge, I appreciate and understand where he came from, and I understand where he had that perspective. When I was an attorney that had only been practicing a few years and never done a deposition before, I didn't know. I did immediately call Stan. I literally was in my car on the way home from the courthouse. So, again, I felt like I had a really good relationship with Stan. We talked a lot. And I think that goes a lot to some of this too, the timeline and the events that occurred. The understanding that I had with Stan was that this was headed towards a diversion. At that time, it got delayed, COVID happened, my heart transplant happened, all sorts of things happened, this came on. And I think it was still headed that way until the Judge Comer complaint. And then Stan retired, and that's how we ended up here today. So, I would make a minor point that, I don't think that the statements to Ragsdale were an intentional misrepresentation. What I said to her was something to the extent of I thought the check was in the mail. I think that probably all of us have said something like that to someone that money is to be paid to at some point in our lives. What I would acknowledge is that it was a negligent misrepresentation. I mean, I shouldn't have said that. It's not, now if that kind of question comes up, the answer is, let me get to my records. Let me look. Let me get to you. I did not take that seriously enough, and honestly didn't take these proceedings initially seriously enough either, with the very informal relationship that I had knowing Stan. We would call each other and that kind of thing. I don't think I need to say much about the garnishment case. There hasn't been much discussion about it, but I believe the panel was correct in their findings. It was a very difficult situation with a person with the same first, middle, and last name. In good faith, I garnished the wrong person. And, the funds immediately were put into escrow. I, in fact, replaced funds that had already been paid out to my firm, got them in escrow the minute there was an issue. I had suggested it go before the court. They didn't want to do that. And so we kind of ended up where we were. And that's where that is. Lastly, Judge Comer. I've gone to Judge Comer and apologized. I definitely interrupted. I was rude. I would categorize it as overzealous. As you noted, I was on a lot of drugs, including steroids at the time. My wife can tell you as much as anybody that it affected my temperament. And sometimes I was a little quicker to get to something. That absolutely affected my interactions with the judge. I did wholeheartedly believe what I said at the time. And I do think, Your Honor, that there has to be, if there is a finding that of the violations in the Judge Comer case, well, not the courtroom decorum. Obviously, you don't really have to make any determinations about. I did interrupt him. I made mistakes. It was again, learning experience, everything at the time. It also was a Zoom hearing, which tended to be more informal on that kind of thing. You know, I'm not going to argue on that. I did step over the line that I should have. I should have been more reserved. I do think there's an argument, which I will leave to you all to decide, whether it's disciplinary, as in attorney discipline standing before you versus, you know, a $500 fine to the court or something like that, that I've seen happen to other attorneys in cases I've been involved in. I think that's a question, but I'm not going to argue that either way. I should have been more reserved and respectful in the courtroom, and I wasn't. You know, with regards to the response to the complaint, though, as you noted, the complaint, he did state during the hearing that he was leaving town, and that was one of the reasons for his decision. He did state, you know, again, in the response, I felt like I was responding. I responded too quickly. I should have sat back and waited. And now in all of my life, I have a 24-hour rule, and I should have had it there too and written a more thoughtful response. But there was no intention to disparage him. Again, I've spoken with him about this personally and apologized to him. And it was just my belief at the time, which may be wrong. And I think he's brought more evidence and more conversations with me to acknowledge and understand that it probably was wrong, but it is based on the facts that I had available at that time. My last 2 minutes, I just want to focus on what I would suggest is the appropriate punishment here. Again, I think that it's important that you look at the specifics of the case. Hopefully do appreciate some of the background of where I got here and where I am now, how I've grown, how I've changed, how I've tried to correct everything that's alleged here. Mr. Volkersberg didn't say it, but it's been in the briefing and he might say it when he comes back up here. And I know the panel said it, that this contention that fraud and dishonesty requires a suspension. I would suggest that this court has never said requires. This court has said that it's generally not advised. And you have, in several occasions, not given suspensions to people who have been found to have been guilty of fraud and dishonesty. The most recent being what I believe is your most recent decision in Ray Morton, where a young woman lawyer, similar kind of practice time as me, was found to have made some misrepresentations, and the panel decided for censure. You know, I would suggest that there are similarities here between this case and that case. None of my clients made these complaints. There were no harm to any clients, obviously, from anything that took place here. As you noted, Justice, the court reporter was paid back within the appeal period of the small claims case, so there was nothing there. I made mistakes. I'm human. I admit that. But again, I think that hopefully these circumstances would help you to see that this is one of those cases where a lesser punishment, I would ask for censure, but really what I'd ask for here today is a stayed suspension pending probation, continuing my probation supervision by Ms. Whelan, Cheryl, and moving forward, because I want to acknowledge that, again, there are things I could have done differently. There are things that I would do differently if I could go back to that situation. But I would just ask that you not take away my ability to provide for my family. And in my last 20 seconds, that's what I just want to say is that any kind of suspension of any time would be disproportionately punishable to me in my life situation as opposed to others that come before you. With my health situation, I don't know how many more years I have to live. I am already facing failure with my heart, which is why we had to continue the last hearing the last time we were here. I may only be here a few more years. I'm the sole provider for my family, and even 90 days without being able to make income could really hurt us and our kids. So I ask that you keep that in mind, and the disproportionate effect that a suspension would have, and that there are other alternatives here which would allow me to continue to take care of my family while still recognizing the situation and acknowledging what happened and punishing as you deem appropriate, but maybe not taking away that ability to provide. So
Let me ask you about the possibility of a probate. And since you're not litigating and you've got a title company, I'm curious as to what role you would a probation plan playing with current business model.
I appreciate that question wholeheartedly. Admittedly, Cheryl does not have a direct supervision over my title business because it is title, not the practice of law, and is a little different. We do talk about it though. We do, to the extent that there is interaction between even people who aren't licensed attorneys who own title companies. There's interplay in what I would consider probably legal practice. We could argue, you know, where that falls. It's kind of like real estate agents, right? I mean, there's gray. We have those discussions. She's there for me if any kind of ethical question came up. We talk about general business practices. that kind of thing. So I do think it still plays a role. I do think she's still there supportive and supervising. If this court was to suggest, I did not put someone in place to supervise my title company because it is not technically legal practice, but if that is something that this court felt was appropriate, I would not be opposed to that and would be happy to locate their several Kansas bar attorneys, for example, that also own title companies who I know and could ask if the court felt that, deemed that appropriate.
So you have an ongoing transactional practice in addition to the title work? Is that, are you just phased out litigation, or what scope of legal work are you currently doing?
Yeah, so I have the one case that is being finished up that Cheryl is supervising. Outside of that, I have not taken any new legal clients since early 2022. And so the plan is not to practice law in a traditional sense. And I know that that garners the question, so why would a suspension hurt? My title practice and my ability to be underwritten by Old Republic is predicate on me being an attorney. That's how I was able to open the title company in the first place. And without that license, it's not guaranteed they would take it away, but I'd consider it a very high probability since that's the basis that they came. So I'm not practicing law, actual paying clients in that sense, providing legal advice. But again, there's a lot of interplay between title companies and attorneys, so.
I believe the record had original and a supplemental probation plan that you submitted, but it doesn't, I don't know that those are necessarily still relevant to what to the arrangements that you would have today. Is that correct? Have you updated the probation plan, and have you filed any affidavits of that you have implemented the probation plan, or had any reports from Ms. Whalen filed with the court?
Yes, Chief Justice, she has been making quarterly reports and she's been sending them to the Office of Disciplinary Administration. To my knowledge, I do not believe anyone has filed them with the court. They could be obviously filed with the court, and I would happily do that today if the court would like to look at it. She has been making those quarterly reports. She has analyzed each of the elements of the probation plan. In each report, I have completed all the additional CLE that was proposed, and actually a little bit more than that. I have completed a psychological evaluation that again was also provided to the ODA prior to appearing here today, and I would also be happy to share that with the court. And so, yeah, she has been making those quarterly reports. She's been very regimented about it and pretty detailed in the reports. The advice we were given was just to file those with the ODA at this time. But again, I would happily share them with the court if desired.
Thank you.
Thank you, Justices. I appreciate your time.
Oglesberg?
Regarding the point that you just made, Chief Justice, there has not been an affidavit filed with the court that Mr. Davis filed under Rule 227 to show that he's in continued compliance with his probation plan. Regarding the quarterly reports, I have received the 3 quarterly reports that would be due from Ms. Whalen, and she has said in those reports that he is complying with his probation plan. But Mr. Davis, 14 days prior to this hearing, has a requirement under Rule 227 to file an affidavit with the court saying that he is in compliance, and he did not do that. Unless there's any other questions.
I've got
from the
one.
court.
Let's assume, I mean, your recommendation of indefinite suspension is based upon you winning all your exceptions and getting all. Right?
Sure.
Okay, so let's just assume we stuck with the findings that the hearing panel came up. Where are you on recommendation?
What would be my recommendation at that point? I would just make a recommendation of a definite suspension with a reinstatement.
What period of time?
$6 months and 1 year.
And why the reinstatement hearing?
Because during the hearing, Mr. Davis was talking about all the medications that he was taking, heart issue, and talking about the emotional issues that he was having that resulted in the misconduct, especially in front of Judge Comer. Usually when an attorney puts forward evidence saying that I was dealing with these things, or I'm currently dealing with these things that caused the conduct, we would like to have a reinstatement hearing to know that those have been resolved and that they can proceed forward with practicing law.
Have there been any issues since the Judge Comer?
Other than, I mean, in my
Been
opinion.
the
dishonest
issues that
conduct,
you
but no,
personally,
we have
that
no-
you and the office have had?
We have not received any new complaints against Mr. Davis since Judge Comer filed his complaint,
And that was when?
October of 2020.
So it's been over 3 years. So given that time period has elapsed, do you still feel strongly about a reinstatement hearing?
And the big key issue at the hearing was determining whether or not these were truly mistakes or whether this was intentional misconduct, especially against Ms. Ragsdale. In my mind, and I argued that Mr. Davis never acknowledged the true extent of his conduct. Also, in addition to that, when he filed his initial answer to my amended complaint, he tried to suggest that LY, his client, was simply just not remembering our conversation when he requested an appearance fee check from her. So to me, that was an example of dishonest conduct in his answer. And so in the combination of that, I believe that a reinstatement hearing would be applicable into this case.
How many years ago was that?
That was in
2019,
2022,
2022?
answer to my formal complaint that I filed.
No complaint?
Thank you.
Thank you to both counsel for your arguments in this matter today. We will take this under advisement. Our docket for the week, this week's docket is now adjourned.